Assalamualaikum. We are from Group 1 and today we will be presenting our topic, which is Clause 5 until Clause 25 based on the contract. So we will start our presentation with Clause 5, SO's instruction. The comparison lies in the authority and procedures for issuing instruction. PWD 203A, Clause 5, and CIDB 2000, Clause 3, designate the superintending officer, SO, as the responsible party, whereas PAM 2018, Clause 2, appoints the architect for this role. All require instructions to be in writing and involve similar scopes, such as variations, compliance, and defect rectifications, which contractors are obliged to follow. The main difference is simply the title and role of the issuing authority. The law case for this clause is Sunisa Sdn Bhd versus Kerajaan Malaysia and ANO 2020. This case involved a dispute over a construction contract based on the PWD 203A standard form. The contractor was appointed to construct a 10-story court building in Kuantan, Pahang. During the project, 4 extensions of time were granted due to delays not caused by the contractor. After completing the project within the extended time, the contractor claimed for loss and expense arising from the EOTs. The Government of Malaysia rejected the claim, arguing that the contractor failed to comply with the contractor's requirement to provide prior written notice of the intention to claim for loss and expense within 30 days of the event causing the delay. So, the High Court upheld the government's position, emphasizing that the prior notice requirement was a condition precedent. Since the contractor did not fulfill this requirement, the court dismissed the claim for loss and expenses. Next is Clause 6, Scope of Contract. Under PWD 203A, Clause 6, the contractor must complete all work clearly listed in the contract. PAM 2018 also requires this, but allows more flexibility for changes and extra work. CIDB 2000 focuses more on teamwork and performance, making sure everyone understands their roles from the start. The law case that related to this clause are Pembinaan Leo Tuk Choi and Sons Sdn Bhd versus Dr. Lilas Medical Centre Sdn Bhd, 1995. The contractor was hired to build a medical centre. A dispute arose when the employer claimed that certain works were not completed properly or were outside the agreed scope. The contractor argued that they had completed the works based on the contract and that any additional works was due to the employer's instruction, not part of the original scope contract. So, the court held that the contractor had carried out the work in line with the scope stated in the contract. It emphasized that clear contract terms are crucial in defining the scope of work and that any additional work must be supported by proper instruction or variation orders. The decision favored the contractor, reinforcing that contractors are not responsible for extra work unless it's officially instructed and documented part of the original scope of contract. Next, Clause 7, Contract Sum. The comparison of the contract sum provisions in PWD 203A, PAM 2018 and CIDB 2000 lies in their approach to adjustment. PWD 203A emphasized government-specific procedures for variation and pricing. PAM 2018 focuses on the architect's role in certifying variation and interim payments, while CIDB 2000 provides a broader framework for adjustment, including variations, provisional sums and fluctuations tailored to the construction industry. The law case related to this clause are Syarikat Pembinaan Anggerit Sdn Bhd versus Public Works Department. This case involved the PWD 203A standard form of contract. The contractor argued that the verbal instruction from the SO led to additional works, which increased the project cost. However, the Public Works Department contended that no written instruction were issued, and therefore, the contractor was not entitled to claim additional payment. The court ruled in favor of the Public Works Department, emphasizing that compliance with the contractual requirement for writing instruction was mandatory. The absence of writing confirmation from the SO meant that the contractor's claim for additional payment could not be upheld. The next clause is Clause 8, Contract Documents. PWD 203A emphasized government standard forms and specifications. PAM 2018 focuses on architect-led contract administration with drawings and agreements, while CIDB 2000 provides a broader industrial-based framework incorporating technical documents, schedules, and construction standards to accommodate diverse project requirements. The law case for this clause are Syarikat Bina Jaya versus Majlis Pembandaran Klang 2015. Syarikat Bina Jaya was awarded a construction contract by Majlis Pembandaran Klang under the PWD 203A standard form. During the project, disputes arose regarding discrepancies between the contract documents, particularly the specifications and drawings. The contractor argued that certain instructions issued by the superintending officer contradicted the original contract documents, leading to additional costs and delays. So, the High Court ruled that the contract documents, including specifications and drawings, must be read as a whole and any inconsistencies should be resolved based on the hierarchy of documents outlined in the contract. The court found that the contractor was entitled to additional payment for variations caused by conflicting instructions, as the SO had issued directives that deviated from the agreed contract documents. However, the contractor was also held responsible for failing to seek clarification before proceeding with the works. Next clause is Clause 9, Representations, Warranties and Undertakings of the Contractor. PWD 203A, PAM 2018 and CIDB 2000 all outline the contractor's obligations regarding representations, warranties, and undertakings, ensuring compliance with contractual terms, quality standards, and legal requirements. However, PW203A focuses on government-specific expectations, PAM 2018 emphasized the architect's oversight in private sector projects, and CIDB 2000 provides a broader industry framework for contractor responsibilities in construction works. The law case chosen for this clause are Aster Bina Sdn Bhd and ORS versus Leba Daun Development Sdn Bhd 2024. Aster Bina Sdn Bhd was engaged as the contractor for a residential development project under a CIDB 2000 base contract. The dispute arose when the developer, Leba Daun Development Sdn Bhd, alleged that the contractor had misrepresented the quality of materials used and failed to meet the agreed construction standards. The contractor had provided warranties regarding compliance with specifications and undertook to rectify defects, but the developer claimed these obligations were not fulfilled. The court ruled that the contractor had breached its warranties and undertakings by failing to deliver the agreed quality of work. It emphasized that representations made by the contractor regarding material quality and workmanship form part of the contractual obligations. Since the contractor did not rectify the defects as required, the court awarded damages to the developer for the cost of remedial works. Jump to the next clause, Clause 10. Obligations of the contractor. PWD 203A, PAM 2018, and CIDB 2000 all outline the contractor's obligations to execute the works in accordance with the contract, but they differ in emphasis. PWD 203A focuses on compliance with government-specific requirements. PAM 2018 highlights the contractor's duties under the architect's supervision. And lastly, CIDB 2000 provides a broader industry framework, emphasizing adherence to technical standards and construction practices. The law case related to this clause are Sime Darby Engineering Sdn Bhd versus Public Work Department 2018. The dispute arose when the contractor failed to meet the agreed timeline and deliverables, citing unforeseen site conditions and delays in receiving instruction from the SO. The Public Works Department argued that the contractor did not fulfill its obligations to mitigate delays and ensure compliance with the contract terms. So, the court held that the contractor was in breach of its obligations under Clause 10 of PWD 203A, which outlines the contractor's duty to execute the works in accordance with the contract. The court emphasized that the contractor had a responsibility to notify the SO of any issues affecting progress and to take reasonable steps to address delays. Damages were awarded to the Public Works Department for the losses incurred due to the contractor's non-compliance. Next is Clause 11, Inspection of Site. PWD 203A focuses on assessing specific conditions like soil structure and access. PAM 2018 highlights integration of design and construction with thorough documentation. And CIDB 2000 stresses technical analysis to address challenges in diverse industry contexts. The law cases related to this clause are Perbadanan Kemajuan Negeri Selangor versus Syarikat Pembinaan Serta Sdn Bhd 2019. The dispute arose when the contractor encountered unforeseen underground utilities during excavation works, which were not disclosed in the site information provided. The contractor claimed additional costs and an extension of time, arguing that the site inspection clause did not require them to identify hidden conditions. PKNS contended that the contractor failed to conduct a true site inspection as required under the contract. So, the court ruled in favour of PKNS, emphasizing that the contractor had an obligation under the site inspection clause to assess all visible and reasonably foreseeable site conditions before commencing work. The court held that while the contractor could not be expected to identify hidden utilities, they should have raised concerns about incomplete site information during the pre-commencement stage. As a result, the contractor's claim for additional costs and an extension of time was dismissed.
Hi, I'm Adam. So today I'm gonna explain about Clause 12 to Clause 18. So about the Clause 12, Program of the Work, comparison between PWD and PAM and CIDB. Clause 12 of the PWD and CIDB form and Clause 21 of the PAM form all require the contractor to submit a program of work, but differ in purpose and enforceability. In the PWD and PAM form, the program is mainly for planning and monitoring, not controlling binding, and may be revised upon instruction. In contrast, the CIDB form treats the program as a binding document once approved by the super-tendering officer, making it a key reference for progress tracking and extension of time assessment. About the law case, the law case is Jabatan Kerja Malaysia and Anwar versus Sanisa Sdn Bhd 2022. The case facts is the contractor experienced delays due to factors beyond their control. However, the contractor failed to provide timely written notice as required under Clause 44.1 of the PWD contract. The court emphasized that adherence to the notice requirement is crucial, and failure to comply can result in the forfeiture of entitlement of extension of time or compensation regardless of the legitimacy of the delay causes. This case underscores the importance of maintaining an accurate and updated program of work and strictly following contractual procedures to safeguard entitlements. So next is clause 30, which is performance bound. Comparison between PWD, PAM, and CIDB is clause 13 on the performance bonds in the PWD, PAM, and CIDB forms generally requires the contractor to provide a performance bond as a guarantee for the proper execution of the contract. In all three forms, the performance bond is usually set at 5% of the contract value. The bond remains valid throughout the contract's duration and is released only after the completion of the defects liability period, once the works are certified as complete. The PWD and CIDB forms both stipulates that the bond is issued by a bank or insurance company and remains in effect until the expiration of the defects liability period. Similarly, the PAM form also requires a performance bond of the same amount and ensures its release after the defects liability period, contingent on the architect's certification. Despite these shared requirements, all three forms aim to provide a financial safeguard for the employer, ensuring that the contractor fulfills their obligation under the contract. So about the law case, which is the name Syarikat Ong Yok Ling Sdn Bhd versus Green Dynamic Builders Sdn Bhd. The case fact is in the matter of Syarikat Ong Yok Ling Sdn Bhd versus Green Dynamic Builders Sdn Bhd 2023, the High Court addressed the issue of restraining the beneficiary from calling on bank guarantee during ongoing arbitration proceedings. Syarikat Ong Yok Ling Sdn Bhd, the subcontractor had provided a bank guarantee to Grand Dynamic Builders Sdn Bhd, which is the main contractor, as security for the performance of subcontract works on the 8 Conley project. The subcontractor alleged non-payment of certified sums and wrongful suspension of works, leading to increased costs. In response, the main contractors sought to call on a bank guarantee. However, the High Court grants an interim injunction to prevent this, ruling that the intention to call and the guarantee was unconscionable under the circumstance. The court also ordered the subcontractor to renew the guarantee if arbitration proceedings extend beyond its expiry. So we're going to the next clause, which is indemnity in respect of personal injuries and damage to property. The comparison is clause 14 of the PWD, PAM, and CIDB forms all deal with indemnity in respect of personal injuries and damage to property, requiring the contractor to indemnify the employer for any claims related to personal injury, death, or property damage arising from the contractor's works. In all three contracts, the indemnity covers injuries to the contractor, employees, third parties, and damage to both public and private property. However, none of the contracts hold the contractor liable for claims arising from the employer's own negligence or the negligence of the employer's agents or the employees. In terms of insurance, the contractor is required to maintain adequate insurance to cover these liabilities in all three forms. While the provisions are similar, the PAM form explicitly implies the exclusion of liability for the employer's negligence, and this is similarly reflect in the CIDB form. Overall, the indemnity obligation is consistent across these forms, with the contractor being responsible for third-party claims but not for claims arising from the employer's action or negligence. And for the law case is Bayer Malaysia Sdn Bhd versus 100 Vision Construction Sdn Bhd 2020. The case fact is the High Court deal with disputes where the buyer, the nominated subcontractor, which is NSC, was accused of causing damage to an adjacent building during construction work, although there was no direct contract between the employer and the NSC. The court ruled that the NSC owed a duty of care to the employer because they would directly impact the employer's property. The court emphasized that this duty was fair and reasonable. given the interconnect roles in the construction project. This case highlights that in the Malaysian construction industry, parties can be held liable for negligence even in the absence of direct contractual relationships, as long as their actions affects the interests of others involved in the project. So the next clause is clause 15, which is insurance against personal injuries and damage to property. In clause 15, in PWD, PAM, and ZDB forms require contractors to maintain insurance for personal injury and property damage during construction. In PWD, the contractor provides coverage for third-party injuries, workers, and property damage with costs borne by the contractor and potentially reimbursed. PAM also requires similar coverage but includes additional provisions such as naming the employer as a co-insured and requiring certificates of insurance. The CIDB follows similar requirements but offers flexibility in agreeing on insurance limit, with the contractor covering the insurance costs typically included in the contract sum. While all forms ensure basic coverage, PAM has more detailed documentation requirement. So for the law case, the name of the case is Chris Ansana Sinemberhad versus Yu Sim Chuan and Anna 2007. In the case of Yu Sim Chuan versus Chris Ansana Sinemberhad, the plaintiff Yu Sim Chuan owned a house next to the land being developed into condominium by Chris Ansana Sinemberhad. During the construction, the defendant carried out piling and excavation work, which caused the ground to shift and damage the plaintiff's property, including cracks in the walls and floors. The court ruled that the defendant was negligent and failed to take proper precaution to prevent damage. As a result, the defendant was held responsible and ordered to pay damage to the plaintiff. This case highlights the responsibility of construction companies to ensure their work does not harm neighboring properties. So the next clause is clause 16, which is indemnities to government in respect of claims by workmen. Clause 16 in the PWD, PAM, and CIDP forms all require the contractor to indemnify the employer against any claims for workmen or subcontractor workers due to injury or death caused by the contractor's negligence. The contractor is responsible for all costs, including legal fees arising from such claims. All three forms emphasize the contractor's obligation to ensure safety on site and comply with relevant safety regulation. While the language may vary slightly, the core requirement of indemnification and the contractor's duty of care are consistent across these forms. So about the law case, Tanjung Offshore Services Sdn Bhd versus Bumi Armada Offshore 2007. So the case facts is the contractor Tanjung Offshore was held responsible for indemnifying the employer Bumi Armada Offshore in relation to a claim made by a worker who suffered personal injury during the course of the project. The court ruled the contractor was liable for the worker's injury under the indemnity clause in the contract, as the injury was caused by the contractor's failure to adhere and to the safety requirements and proper care for the workers' safety. So next is clause 17, which is Employees Social Security Act 1969. Clause 17 of the PWD form requires the contractor to register and contribute to SOCSO for all workers under the Employees Social Security Act 1969 and to indemnify the government against any claims due to non-compliance. In comparison, the PAM form does not have a specific clause for a social security but includes general obligation for the contractor to comply with all statutory requirements, which implicitly covers SOCSO and other employment-related law. The CIDP form similarly implies statutory compliance, requiring contractor to fulfill obligation under relevant labor laws, including SOCSO, EPF, and EIS, without a dedicated clause like PWD clause 70. So about the law case is case pekerja-pekerja pembinaan versus Rainhi Bersekutu Sinemberhad 2009. The case file is this case involved a dispute over the failure of a contractor to contribute to SOCSO for its workers, resulting in a worker's injury on the job. The court has examined whether the employer was in compliance with the Employees Social Security Act 1969. The workers' union argued that the contractor had failed in its statutory duty to register the workers and contribute to SOCSO, which was a violation of their rights under the law. So the last clause from me is clause 18, which is insurance of works. This clause, clause 18 of the PW, PAM and CIDB contracts all require the contractor to insure the works against risks like fire, theft, natural disaster, as well as provide coverage for third-party and employer liabilities. In all three contracts, the contractor is responsible for paying premiums, though this may be reimbursed by the employer. While the PAM contract focuses on basic all risk and public liability coverage, the CIDB contract may include more detailed provision, especially for larger projects, and professional indemnity insurance. The PW contract generally aligns with the others but can have more specific government-related stipulation regarding claims, procedures, and the handling of premiums. The employer is typically named as an additional insured party in all cases. So for the law case, which is Kuala Lumpur City Hall versus Syarikat Pembinaan Setia Sdn Bhd 1999, the case fact is the contractor failed to secure the required all-risk insurance for the construction works as stipulates in the contract. A fire caused significant damage to the works, and the court had the contractor liable for the loss due to their failure to insure the project. The case reinforced the contractor's obligation to maintain insurance coverage during construction, as outlined in clause like clause 18 of PWD, PAM, and CIDB contract. It emphasized that if the contractor neglects this responsibility, they are liable for any resulting damage.
Assalamualaikum and good day everyone. Today I will present a detailed comparison of the clauses under the PWD Form 203A, PAM Contract 2018 and CIDB 2000 Standard Form, focusing on 7 important topics: setting out unfixed materials and goods, compliance with the law, design responsibility, uh, employment of workmen, variations, and also measurement and valuation of works, including variations. So we go firstly under setting out. The PWD Form 203A makes the contractor fully responsible for the true and proper setting out of the works, including positions, levels, dimensions, and alignments. Any error must be rectified at the contractor's expense unless it is caused by incorrect written data from the superintending officer's representative. Meanwhile, the PAM Contract 2018 similarly places the responsibility of setting out on the contractor but allows the architect, with the employer consent, to waive rectification of an error subject to a deduction in payment. On the other hand, CIDB 2000 requires the superintending officer to provide original reference points and allows the contractor to rely on them. However, the contractor still bears the responsibility for correct setting out. If the error is due to the reference points, the employer bears the cost. If due to the contractor must bear it. This principle was confirmed in the case of Perembas Sendirian Berhad versus Gemencir Granite Sendirian Berhad, where the court ruled that the contractor was fully liable for incorrect setting out despite the employer's representative prior approval. And secondly, on unfixed material and goods, under the PWD Form 203A, unfixed materials delivered to or near the site become government property once their value has been certified and paid, though the contractor remains liable for any loss or damage. Similarly, in PAM Contract 2018, once payment is made under Clause 30.2, the materials become the property of the employer and the contractor remains responsible for loss or damage and warrants title free from encumbrances. In contrast, CIDB 2000 does not have a specific clause for unfixed material, but it requires quality control, testing, and the contractor's responsibility to remove defective goods at their cost. This principle reflected in Shinsin Motorworks Sendirian Berhad versus Arosa Development Sendirian Berhad, where the contractor was held liable for the wrongful removal of paid materials. And thirdly, regarding compliance with the law, the PWD Form 203A requires the contractor to comply with all statutory requirements and to indemnify the government against penalties. If a change in law after the date of tender affects the works, the contractor must notify and seek instructions. The PAM Contract 2018 similarly imposes compliance duties but makes the employer responsible for plan approvals and also for delays caused by public authorities. CIDB 2000 follows similar compliance obligations but specifically provides that changes in law resulting in cost increases must be certified and adjusted in the contract sum. In Mudajaya Construction Sdn Bhd and Leighton Contractors Sdn Bhd, the court affirmed that where a change in statutory requirements caused additional costs, the contractor was entitled to variation and also compensation. Moving on to design responsibility, under PWD Form 203A, where the contractor undertakes standalone design, they are fully responsible for ensuring that the design is suitable, safe, and also compatible, prepared by a registered professional and backed by a design guarantee bond of 5% for 5 years. PAM Contract 2018 allows contractor propose alternative designs and clarifies that even if accepted by the architect, responsibility remains with the contractor. CIDB 2000 also imposes full design responsibility under Module D without the requirement for a design bond. This was emphasized in SIME Engineering Sdn Bhd versus Government of Malaysia, where the court ruled that the contractor liability for design defects remains even if the employer or consultant approves the design. Next, under employment of workmen, PWD Form 203A requires the contractor to employ only Malaysian citizens unless non-availability is proven and approval is given. The contractor must also comply with employment laws and ensure proper wage and time records are maintained. In contrast, PAN Contract 2018 has no strict nationality requirement but obligates the contractor to allow other contractors engaged by the employer to perform work on site. CIDB 2000 requires the contractor to handle all labour arrangements, including compliance with immigration and labour laws. In Asas United Construction Sdn Bhd versus Kepala Batas Bina Sdn Bhd, the court held that the contractor was responsible for ensuring all workers, including those of subcontractors, had proper work permits. Now on the variations, PWD Form 203A Clause 24 gives the superintending officer wide discretion to order variations, including changes in design, quantity, and materials, without invalidating the contract. PAM Contract 2018 Clause 11 similarly allows variation through architect's instructions, but specifies that variations caused by contractor negligence are at the contractor's own cost. CIDB 2000 Clause 28 also allows variation and adds that contractors can seek clarification if an instruction is unclear. In Capital Habit Builders Sdn Bhd versus Persona Metro Sdn Bhd, the court stressed that the variation claims must be based on written instructions, while Sunisa Sdn Bhd versus Kerajaan Malaysia emphasised that failure to provide timely written notice can bar claims for additional costs. And finally, of works including variations, PWD Form 203A Clause 25 requires variation to be valued first using contract rates, then adjusted rates if conditions differ, and fair valuation or day work if necessary. PAM Contract 2018 Clause 11.5 to Clause 11.7 follow the same structure but introduce strict procedures requiring contractors to submit full particulars within deadlines or risk losing payment rights. CIDB 2000 Clause 29 also applies a similar hierarchy while providing contractors a right to dispute the valuation within 30 days In Bina Jati Sdn Bhd and GSC Estate Management Sdn Bhd, the court dismissed a contractor's variation claim because of insufficient documentation. In Pembinaan Yang Tong Sdn Bhd versus Meru Valley Resort Berhad, the court accepted variation claims were proper notice and documentation provided showing the importance of following valuation procedures strictly. In conclusion, while PWD places more rigid control and responsibility on the contractor, PAM offers some flexibility demands the but demands strict procedural compliance, and CIDB emphasise fairness, transparency and dispute resolution mechanisms. That's all from me. Thank you.